Until the Great Depression set in the 1930s, after the stock market crash of October 1929, securities law was entirely state law. The states had what are still referred to this day as blue sky regulations. And in many respects, these state laws are more substantively oriented than the federal laws. In other words, the state laws actually empower administrators to look at proposed securities offerings and determine whether, in fact, they make any sense, and perhaps reject them on the grounds that they simply are not good investment opportunities. The federal laws do not do that. The federal laws were created in the aftermath of the Great Stock Depression, economic depression of the 30s. Eventually, Congress got in the act and passed the Securities Act of 1933 and the Securities Exchange Act of 1934, empowered the newly founded agency, the Securities and Exchange Commission, to regulate in this field, and numerous laws have been passed since then. The most recent prominent law being the Sarbanes-Oxley Act of the summer of 2002, passed in the aftermath of the scandals associated with Enron, WorldCom, Global Crossings, etc. The fundamental focus of federal securities law, which tends to cover pretty much all the large companies, all the large offerings, all the interstate potential securities, is information, access to information on the part of possible investors. The worry is that investors may be so enraptured in sort of a go-go environment, so enticed by sweetly attired, nicely coiffed individuals, that they don't spend the time to really look at what they need to make good investment choices. Well, the federal laws won't really do much for people that simply refuse to look at the information. But what the federal laws do try to do is say that if you want to find information, we will make it available to you. We will require businesses to furnish the information that you can use in determining whether you want to invest your money in a particular securities offering. And this applies not only to the IPOs, the initial public offerings, but also to the secondary market, to the exchanges, to the over-the-counter market, NASDAQ, etc. And the idea is we can't protect you if the economy just goes into tailspin. We can't protect you if you make a poor choice or things just happen in the market. But we can try to protect you from people that are glad-handers, that are defrauders, and the like. We will make regulation there to require them to disclose information, and if they fail to do so, to give you and the government an ability to go after those defrauders and those negligent parties and those others associated with either stock fraud or at least stock negligence, you might say, and give people an opportunity to sue them, to recover damages, and in very serious cases, to actually proceed in criminal court, to have the Justice Department or others intervene and pursue people with criminal charges. That's the gist of the securities regulation environment. There is obviously much, much more to it. It gets very complex because there's so many players in the system. There are professionals within the system, such as brokers, such as underwriters. There are companies that are involved, and there are various professionals within the companies, such as attorneys or accountants or even accountants or other professionals working on retainer for companies. There are, of course, consumer groups. There are pension fund participants. There are governments. There are state governments that proceed after alleged fraud. There's the Justice Department. There are securities agencies at the federal and state level. Many, many, many different players. But the notion is if everybody does his part, then in most instances, people will be able to make informed judgments, and hopefully the playing field will be relatively level in terms of the ability of people, whether they are insiders or not insiders, to make informed decisions vis-a-vis their investments.